Hi, this is David Magnus. I'm director of the Stanford Center for Biomedical Ethics, where I'm professor of pediatrics and medicine. Today I'm going to be talking to you about research ethical issues that are specific to pediatrics as opposed to the general requirements for research ethics and human subjects protection, which are contained in another video. One of the things that we tend to think about when we think about research ethics is a concern about we've got certain approaches to research for adults, and then we have sort of smaller versions of it for kids. But in fact, protection of children mean that there are a number of differences and important considerations in research on children. If you look historically at the Nuremberg Code back in 1947, when they first were really pushing the emphasis on informed consent, they said that the voluntary consent of the human subject is absolutely essential, and this means that the person involved should have legal capacity to give consent, which on its surface seems to make pediatric research unethical. And in fact, there was a big debate raging through the 1970s about whether and how you could actually conduct ethically research on pediatric patients who were not capable of giving informed consent. This is a famous Ramsey-McCormick debate. Paul Ramsey, these were both theologian bioethicists. Paul Ramsey said, since there's no consent, research on children who can't give consent is unethical unless it's directly beneficial to them, and rejected the idea that parents could serve as proxy consent for the kids. Richard McCormick, in contrast, said there's an obligation to serve as a research subject, and children under similar obligations to help others, so they have the same duties that everyone else does, and that parents can therefore exercise this obligation on their behalf. The Belmont Report, which we talked about in the other video, came up with a compromise solution to this that would be embodied in the regulations. You can justify research on children, but only if the amount of risk they're exposed to is limited, or there is a benefit to the patient, and that while parental permission is not the same as informed consent, if you have parental permission plus child assent when they reach an age where that's appropriate, that would be considered as the equivalent of informed consent as long as these other conditions are met. As I said, this is codified in the regulations, in which research has to be either minimal risk, offer a prospect of benefit, or a minor increase over minimal risk and meeting certain other requirements to normally approve a pediatric research study. Minimal risk means that the IRB finds that there's nothing greater than minimal risk, and minimal risk means the probability and magnitude of harm or discomfort anticipated are not greater than those ordinarily encountered in daily life or during the performance of routine physical or psychological exams or tests. And of course, informed consent, that is parental permission and child assent, is also important requirement as part of this. The other option, the intervention could be more than minimal risk, but the intervention could hold out the prospect of direct benefit. In that case, the IRB must find that the risks are justified by the anticipated benefit, the risk-benefit ratio is at least as good as any alternatives, and again, informed consent, i.e. parental permission and child assent. And then the third option, you could have something that's greater than minimal risk and no prospect of direct benefit, but first it has to be likely to yield generalizable knowledge about the subject's condition or disorder, and the amount of risk can only be a minor increase over minimal risk, and the intervention has to present experiences that are reasonably commensurate with their actual or expected situations, and again, likely to yield knowledge about the subject's disorder or condition of vital importance for understanding treatment, plus parental permission and child assent. And those are the pretty much normal three routes by which research on children is approvable. There is a fourth option if it doesn't meet those requirements. If an IRB finds research presents an opportunity for further understanding, prevention, or amelioration of a serious problem affecting children, there is an option, and there's an equivalent both in the FDA version of these same regulations as well as under the common rule, to consult a panel of experts and find that either one of the above was satisfied or agrees with the IRB finding that the research, even though it's more than an increase over minimal risk and not of benefit to some of the children, nonetheless could be done in accord with sound ethical principles. So, for example, if you're doing a randomized placebo-controlled trial to see if an intervention works, and in order to be able to administer that, you have to have a PICC line placement or some kind of port placement in order to be able to do that. For the kids who are getting the placebo arm, they are not getting any benefit from being in the research trial, even though this might be life-saving for others with that same condition. And then the placement of the PICC line is generally regarded as more than a minor increase over minimal risk, and so it can't be approved under the regulations, and therefore it would require action of either the FDA or the DHHS in order to allow the research to go forward. Now, what does it mean to say that the risks are the risks encountered in daily life? What does that mean when we're trying to understand the meaning of minimal risks? And there are two different views on this. The subjective interpretation, the risks are the risks of everyday life for this particular subject, or the objective standard that risks are everyday life for the average healthy child. The arguments in favor of subjective standard are that the benefits have to use a relative standard. In clinical practice, when we think about risks and benefits, we use a relative standard. We don't say, gosh, chemotherapy, we should think about the risks of this chemotherapy as if you were healthy to decide if it's worth it. And one of the risks of using an objective standard is it's so restrictive that you wind up having benefit creep, where you count almost anything, no matter how unlikely or improbable, as a benefit. The arguments in favor of an objective standard are that if you didn't have that, if you have a relative standard, you could potentially justify exposing disadvantaged children to greater risk than non-disadvantaged children, and could justify turning dying children into guinea pigs for a wide range of conditions that are irrelevant to their health care, since they're facing such tremendous risk in their daily lives. This debate about the standards gave rise to a very famous case, the Kennedy-Krieger lead abatement study, which was a study to determine the short-term and long-term of efficacy of different levels of lead abatement in older houses in Baltimore that had very young children in them. 6 to 48 months. There were two controls: newer houses that had no lead paint, or houses that had comprehensive lead abatement, which was known to be effective. The problem was that comprehensive lead abatement is very, very expensive. It's not required by the government unless the lead rates are fairly high. And if lower levels of abatement that are cheaper could produce significant effects that are beneficial, it might be possible to have a lot of houses that right now have lead in them to be significantly improved. The outcome measures included analysis of lead in dust and serial blood lead concentration levels in the young children, and this was done in poor urban Baltimore areas, most of which have housing that contains lead paint, and 35% of children suffer some degree of lead poisoning. So this was the lead abatement study. Occupied houses were randomized to low-level or intermediate-level abatement efforts, and vacant houses were randomized to intermediate or high-level abatement effort. They found that all three reduced house dust to differing degrees, and that young children had significantly less lead in their blood in the modern housing. Parents brought suit against Kennedy-Krieger for failing to warn that lead was still present as their children's blood levels rose throughout the trial. And a Maryland Court of Appeals questioned parents' right to even enroll children in a study with non-therapeutic research that presents risks. It wound up being remanded back to a lower court for trial, and Kennedy-Krieger wound up prevailing, though it was very costly to them in terms of their reputation. So was this study minimal risk? Would children living in Baltimore have been exposed to lead anyway and at higher concentrations? Study met local legal standards for whether the lead abatement was necessary, which is a fairly high blood concentration that was not present for any child. And then there's also questions about whether this trial was unjust. So this was a very, very controversial trial. Very controversial trial, and there's difference of opinion in the ethics community about whether or not there was ethically something wrong done in this trial. And again, it hinges on whether or not you think that you want to relativize risk or use an objective standards. Generally speaking, the FDA has moved towards an objective standard as a result of the things like the Kennedy-Krieger study. What is a minor increase over minimal risk, and what counts as the prospect of direct benefit? Is it clinical, surrogate endpoints, what probability, and how do we weigh benefits and burdens? So here's another case study, a study of airway hypoxia in infants. there was evidence that sudden infant death syndrome might be a result of reduction in partial pressure of inspired oxygen, such as during airplane flights. I believe there was some epidemiological evidence that SIDS was slightly higher in infants who had been on airplanes. So they did a study of 34 infants, 21 from an obstetrics service, and 13 SIBs of children who died of SIDS. And the infants were given 15% oxygen and nitrogen, which is roughly the same as they would receive if they were in an airplane cabin, and this was done in a tent. It did require placement of volume expansion capsule on the abdominal wall and an upper cannula on the upper lip to study the effects of oxygenation and apnea. They found variable response. Some infants had to be withdrawn due to hypoxia. So was this a minor increase over minimal risk? So that's and again, this became very controversial with, again, different people on different sides debating whether or not this was an ethical study or not. Another ethical challenge is this notion of pediatric assent or permission versus consent. In general, for children who are under 8 years old, the idea of assent is fairly limited. From 8 to 14, there's a much greater role for the children to play in research and the importance of assent. But 14 to 18 is controversial because in terms of cognitive abilities, those children have the ability to give permission and make decisions, even though they may not be emotionally as mature. But if you want to use most of the evidence we now have from neuroscience about emotional maturity, that doesn't really fully develop until about 25 years of age. And what do we do if a child agrees to research but not the parents, and vice versa? The default is that parental permission is needed, and that's always required under FDA regs, with the possible exception of a waiver for mature adolescents if they have the legal authority to consent to treatment, and for some minimal risk cases, although there need to be other protections in those kinds of cases. So why do we put so much weight on parental permission? Why do we privilege that? And the argument there is that parents know the child best. They're presumed to act in a child's best interest, and they're the ones who are going to have to live with the consequences of decision, in addition to a general social interest in promoting families. And for all these reasons, we wind up putting a lot of emphasis on parental permission, even over and above what investigators might think is best for a child, and sometimes over what the child wants in whether or not they should engage in research.